The anti-choice side has been woke for a whole long time, and
they were caught off guard in the early 70s by the Roe decision, correct?
That's right. You know, on the pro-choice side, there's been plenty of notice that things were going in the wrong direction, but it's been very difficult to motivate and mobilize. So a decision overturning Roe would certainly mobilize.
Hello, I'm Bonnie Bay. Welcome to the Contrary. This week I'm joined by Pulitzer Prize-winning journalist Linda Greenhouse, who writes op-eds on the Supreme Court for the New York Times. A big warm welcome to you, Linda. Thank you so much for doing this.
Great to see you again.
Again, because I covered the Supreme Court when you did for the Times. I was there for NBC Radio Network.
We were press room buddies back then.
So it's great to see you again. But your expertise, you're teaching at Yale now about the Supreme Court. Let's start with Roe. Tell me and explain to people about the trimester system that was set up in Roe.
The court decided there was a constitutional right for a woman to terminate a pregnancy, and the question was under what circumstances. And so the decision was made basically that the dividing line between abortions that would be legal and the abortions that would be strictly limited to preserving a pregnant woman's life and health would be viability, which makes sense when the fetus is able to live outside the womb. Up until the point of viability, of course, pregnancy progresses. And so what the court decided was that in the first trimester, that is to say roughly the first 12 weeks, the state had no role to play, because pregnancy was actually more dangerous than abortion in that period of the pregnancy. In the second trimester, the second 12 weeks, the state could intervene for the purpose of protecting the woman's health. That is to say, could require abortions to be in a hospital or whatever. Third trimester, of course, that's when viability begins. And so that was the trimester system.
So are we talking third trimester viability being without medical intervention?
Well, of course, a baby born early in the third trimester is likely to have quite serious problems and to need medical intervention, a neonatal intensive care unit, whatever. But the notion is that by about 24 weeks of pregnancy, there's at least a good chance that a baby born that premature can survive.
That decision, of course, was written by Justice Harry Blackmun, and it's been criticized for being too ephemeral. Do you agree that the constitutional right allowing women to have abortions should be based on some other right in the Constitution?
Well, I've got a couple of things to say about that. So yes, the opinion was written, quote, written by Harry Blackmun. It was joined by 6 other justices. In fact, by 3 of the 4 justices who Richard Nixon put on the court, Chief Justice Burger, Lewis Powell. Harry Blackmun happened to get the majority opinion assignment from Chief Justice Burger, but it was a collective product. So do I think it should have been written in a different way? You hear that? You hear people say, well, it should have been based not on privacy, not on due process liberty. It should have been based on equal protection. Well, that's a kind of an ahistorical critique of Roe, because at the time of Roe, Roe was under consideration by the court for 2 years. It was argued twice, so 1971, 1972. The Supreme Court didn't yet have a jurisprudence of equal protection for women. That came late. It came soon after that, in part propelled by the abortion case and the birth control case. But for people to say, oh, they should have done an equal protection, they would have had to make it up at that time. So that's really not a well-founded critique.
Do you think it's in trouble now, in jeopardy? Do you think this Supreme Court will accept a case in order to overturn it?
Well, again, there's a lot of things to say about that. What we have today is not really Roe against Wade. We have a case called Planned Parenthood against Casey, which the Supreme Court decided in 1992. It really revised Roe in pretty substantial ways. That's the law of abortion that we're living under today. The key about that is, unlike Roe, which, as I said, gave the state no power to intervene in the early part of pregnancy, Planned Parenthood against Casey, while reaffirming the constitutional right to abortion, said the state has an interest in protecting unborn life from the moment of conception. So Casey gave the states a lot more latitude to intervene. What the court said is that states may endeavor to persuade a woman to carry a pregnancy to term. They can have waiting periods. They can have mandatory counseling. They can have other kinds of things. But at the end of the day, they cannot obstruct. So that's the law we have: persuade but not obstruct. Now, what's the Supreme Court going to do about that? There's lots of ways to obstruct women's access to an abortion. What I think is going to happen, we have all these laws that your viewers know are pouring out of the state legislatures in Alabama and Mississippi and Georgia and Missouri. I don't think those are going to be the vehicles for the court to, quote, overturn Roe against Wade. I think the court will enable the states to impose greater and greater obstructions, which will have the same functional effect, that is to say, will enable the states to destroy the abortion infrastructure, the clinics that are necessary for women to be able to exercise their constitutional right, but it won't look like the court has overturned Roe, so it won't hurt the Republican Party, whose platform this has been for many years, even though a strong majority of the country answers pollsters by saying we do not want to see the right to abortion overturned.
But we know each other from back in the 80s when I covered the Supreme Court and you were the beat reporter for the New York Times back then, not writing op-eds, which is a step above. But I always used to think back then, when it was Scalia and Thomas, they were the furthest right, that they would do what you have just said, uphold Roe, which is already skeletal in a sense, because it has so many exceptions that a lot of women live in red states that are in a post-Roe environment.
That's right, there's only one clinic in an entire state.
Or, even, or with 3-day waiting periods and all those sorts of things.
Right.
But now with Gorsuch and Kavanaugh, the two appointees from President Trump, these are such sort of out there, cantankerous, if you will, people, and so far right that I have thought, anyway, watching the court, that this may be the court that just says, too bad, it's done, it's gone.
It may be, but I don't think it's going to happen right away. I don't actually think it's going to happen before the 2020 election. I actually think that's a date that the court may well have in mind. And not to get too deep in the weeds, but I thought the court gave a little signal about this a few weeks ago. There was a case pending from Indiana. Indiana had passed a law that made it a crime for a doctor to terminate the pregnancy of a woman whose reasons for wanting the abortion were fetal disability, such as Down syndrome, gender, race, the reasons that the state deemed to be inappropriate. And that law was, of course, struck down by the lower court because it flies in the face of settled law. And the court didn't take the case. And the court explained why it wasn't taking the case. And the court said, in the unsigned opinion, so we don't know who's speaking to us, but it seemingly was unanimous or close to it, that we're not taking this case because there's no, quote, conflict in the circuits. There's no other court that has upheld such a law. Now, a conflict in the circuits, again, forgive me for being too deep in the weeds, but I think it's important for people to understand that where the rubber meets the road at the Supreme Court is down on the road, not necessarily up at 1,000 feet. So a conflict in the circuits means we have 13 federal circuits. The court believes that its primary role is to make sure law means the same thing in the Second Circuit in New York as it does in the Ninth Circuit in California. That's why they take a case. Now
They have to take cases, don't they, where
no.
there's a split in the circuits?
No, they don't have to. They don't have to do anything. But they view that as their primary function to make uniform law in the country. So I'm here to say that these laws that are being passed now that are functionally abortion bans, they're all going to be struck down. They have to be struck down by the lower courts who are bound by Supreme Court settled law, by the right to abortion under Roe and Planned Parenthood against Casey. So there's not going to be a conflict in the circuits. And I think the court, at least, as I say, before the 2020 election, is going to content itself by dealing with the obstructions rather than the complete bans.
So, for example, the Deep South laws that penalize, as you mentioned, not just the doctor but also the woman, imprison the woman, right? Those will be struck down by this Supreme Court, you think? Or not taken?
I think not taken. They'll be struck down by the lower courts. Here's an example of...
So they'll be not taken by, they'll be struck down, but the right to life advocates won't then appeal it to the Supreme Court?
I think a case that's really going to tell us what's up is a case now pending from Louisiana. So Louisiana passed a law that said that a doctor who performs abortions has to have admitting privileges in a local hospital. Now this may sound familiar to people because Texas passed such a law a few years ago. And in 2016, the Supreme Court, that was when Justice Kennedy was still on the court, before Justice Gorsuch, before Justice Kavanaugh, the Supreme Court struck that law down and said that's an undue burden on the right of women to terminate a pregnancy. Why? Because hospitals in the red states won't give admitting privileges to doctors who perform abortions, A. B, it's important to understand that doctors who perform abortions don't need to have admitting privileges because the rate of complication from early abortions that are performed in clinics are so low that doctors can go for years without ever having a patient anywhere near a hospital. So these laws are passed in the name of women's health, but actually the desire is to shut down the clinics. So the court overturned the Texas law, overturning a decision by the Fifth Circuit, which had upheld the law. Louisiana has the same law. Louisiana, like Texas, is in the Fifth Circuit. The Fifth Circuit took this law and they said, yeah, we know we were overturned in the Texas case, but that was Texas, this is Louisiana, that was then, this is now, we're going to uphold the law. So the clinics have appealed that case to the Supreme Court. That appeal is pending, waiting for the court to decide whether to hear it, which I'm quite sure they will. That won't come until the fall. And that will tell us whether the court is willing to adhere to its precedents on abortion, because they have the Texas precedent, which is only 3 years old. It was a case called Whole Woman's Health. They have that on the books. And with that precedent, the Louisiana law has to be struck down by the Supreme Court. If the court makes phony distinctions between the Texas law and the Louisiana law, which are for all intents and purposes identical, then we'll see the game is afoot, and it would be clear that the court is definitely on a road to overturn the right to abortion.
Explain whatever insight you may have from having read their decisions, if any are applicable, of Gorsuch and Kavanaugh, and how they might rule in abortion in a, should Roe stay intact case.
There's nothing applicable from Gorsuch as far as I know. There's one data point from Brett Kavanaugh when he was on the appeals court here in DC. There was a really distressing case came to that court involving a pregnant, quote, unaccompanied minor, a young woman undocumented who had come across the border, was picked up, was being held in one of the immigration shelters, learned she was pregnant. She jumped through all the hoops that one has to jump through. This was in Texas. She was able to get herself before a judge where minors need a judge's permission to have the abortion if they don't have parental consent or parental notice. She did all that. The shelter would not let her out to actually have the abortion because the part of the our immigration system currently that deals with the unaccompanied minors is run by a guy whose only credential for that job is that he spent his life in anti-abortion advocacy. So an appeal was brought on her behalf to let her out to have the abortion because every day she was a day more pregnant. And the appeals court let her go ahead. Brett Kavanaugh wrote a separate opinion and he said, you know, we really should wait.
So this was it was 3 judges or 9 judges?
I'm trying to remember. It had a couple of iterations, but the key point is what then Judge Kavanaugh said. He said, we shouldn't rush into this. This is very serious. We should give the government another 10 days to find a, quote, sponsor for her who would sort of take moral custody and be able to make a decision in her behalf. Well, that was ridiculous because she was getting to the point where in Texas she wouldn't be able to have an abortion. She was that close to the end of the second trimester, and she had already done all the right things. So the Louisiana case that we were talking about just a minute ago, when the Fifth Circuit upheld the Louisiana law, the few remaining clinics in Louisiana were going to have to shut down because their doctors did not have and could not get the admitting privileges. So this came up to the Supreme Court as an emergency stay. Grant a stay of the Fifth Circuit opinion so that we, the clinics, can file our formal appeal, which will take some weeks or months. Keep the status quo. And the court granted that stay by a vote of 5-4. Interestingly, Chief Justice Roberts joined the 4 liberal justices in granting the stay. Justice Kavanaugh dissented. Louisiana tells us, he said, that they're not going to start enforcing the law immediately. They're going to wait, I think it was 45 days before they enforce it, even if they have the legal right to enforce it. And in that time, during that time, the doctors should just go back and try to get admitting privileges again. The district court judge made it clear that some of these doctors had been trying to get admitting privileges for 5 years, and it was never going to happen in the state of Louisiana. So why did Justice Kavanaugh say that? Why did he write that? I think I know, which is that he was trying to take a moderate voice, present himself as this sort of reasonable man in the middle between those who granted the stay and the 3 other conservative justices who dissented. He's the only one who wrote on this side on that side. And you know, he fooled a lot of people. If you go back and look at the daily newspaper coverage of that, it was in late January, maybe early February of this year. You say, oh, Kavanaugh was in the middle. No, he wasn't in the middle. He was with the 4 who would have allowed all the clinics to be closed.
So Chief Justice Roberts, in the decision you just mentioned, was deferring to the liberals in a sense, because there's talk about that he wants to preserve his place in history as being seen as a reasonable conservative. Does that give you any hint as to what he might do if a case comes up and they take it that talks about Roe on point? Might he defect from the conservative side?
I actually don't think so, or at least I don't think his action in voting to grant the stay tells us that, because to grant the stay simply preserved the status quo. It was not a decision on the merits. And you know, what he as Chief Justice is presented with in that case is what I would call an act of blatant judicial defiance by the Fifth Circuit, saying, we know you've ruled on this, but we're going to persist in taking a different view of it. So I don't think that vote on the stay engaged his deeper thoughts about the constitutionality of the right to abortion, and that is completely lies ahead as far as I'm concerned.
Are they considering the fact that there may be, who knows, riots in the streets, whatever, if they overturn Roe? Is that playing into their decision making on this issue?
I don't think so, Bonnie. I mean, I'm willing to think that they think they're right. I think that they think that the court made a wrong turn 45 years ago, and part of their job is to bring constitutional law back in alignment with the way they think it should be. And you know, I credit their sincerity in that belief.
The Hyde Amendment, which is now a political issue, how does this play into whatever may happen with Roe at the Supreme Court?
Probably to many people who watched the Joe Biden flip-flop on the Hyde Amendment, the issue sort of came out of the blue from nowhere. But actually, and you probably recall this, in the 2016 election, when it seemed like Hillary Clinton would be the next president and the Democrats could take the Congress, it did seem to people that there was a real chance to get rid of the Hyde Amendment, which, as your viewers probably know, means the federal government will not pay for abortions for women on Medicaid, for poor women. So it was an issue in 2016, maybe kind of under the radar. Should not necessarily have been under the radar for smart politicians, but I think for most people. So now it's back, and of course, if there's no right to abortion, there's no right to get paid for abortion. That's clear. So to that extent, the fate of the Hyde Amendment is tied to the fate of Roe. But I think, you know, it's been a red state, blue state thing for all these decades, because Medicaid is a shared program between the states and the federal government, as we know from the whole Obamacare debate. And so a number of states, mostly California and states in the Northeast, have picked up the cost of abortions for their Medicaid patients, and other states haven't. So I don't see at this moment in our politics that that's about to change.
What do you think the political reaction would be from overturning Roe? Do you think there'd be from your experience, a great public outcry, or because there are now abortifacients that you can get over the counter or fairly easily online with a doctor's prescription, are young women going to all be turning to those as opposed to surgical abortions?
If there's actually a case on the docket that asks them to do that, I think the pro-choice side will finally get the attention of the silent majority who are, we know, in support of the ability of a woman to get an abortion, at least under some circumstances. That's a strong majority of the country. It's even a majority of Catholic women who get abortions at the same rate as any other women in the country. So it would finally wake people up. You know, the anti-choice side has been woke for a whole long time. And
they were caught off guard in the early 70s by the Roe decision, correct?
That's right. And you know, on the pro-choice side, there's been plenty of notice that things were going in the wrong direction, but it's been very difficult to motivate and mobilize. So a decision overturning Roe would certainly mobilize. Now, you also asked about non-surgical abortion, and yes, I mean, we have access to the emergency contraception, the so-called morning after pill, and we have the medical abortion, where you still need access to some kind of medical professional. In a couple of states, it can be a nurse practitioner, but in most states, it has to be a doctor who writes the prescription and so on. So I think people are not going to assume, oh, well, I'll just go online and take care of my unwanted pregnancy. It's going to be a mobilizing moment, I'm sure.
Thank you so much, and thank you for your scholarly knowledge of all this incredible issue that is affecting certainly all American women and really all Americans, period.
We're at quite a moment. We're at quite a crossroads. Thank you, Bonnie.
Thank you. Thanks so much, Linda. That's it for this edition of To the Contrary. Please follow me on Twitter and visit our website, pbs.org/To the Contrary. And whether you agree or think to the contrary, we'll see you next week.
Funding for To the Contrary provided by the Cornell Douglas Foundation, committed to encouraging stewardship of the environment, land conservation, watershed protection, and eliminating harmful chemicals. Additional funding provided by the Wallace Genetic Foundation, the Colcom Foundation, and the Charles A. Freoff Foundation. For a transcript or to see an online version of this episode of To the Contrary, please visit our PBS website at pbs.org/To the Contrary.
Be more PBS.